Hello viewers, our topic is criminal case under section 143, 323, 506 of Penal Code 1860, and this case is a free or this case is simple heart, and simple heart definition under section 319 of Penal Code. And fact of this case is very important part because how to manage the case and how to get the discharge from the case on behalf of the your client accused petitioner, and which grounds is important and sufficient relevant documents submitted before the court. It is very important part. Number 1, section 143, this is the punishment of unlawful assembly of Penal Code 1860, and this ingredients of this section, it will be identified by the allegations against the accused petitioner who can connect it for the purpose of the case. Number 1, bringing allegations unlawful assembly, definitions unlawful assembly, section 141, and member of unlawful assembly, section 142. Member is the connected and having doing the active part or in the offense done by him or them. It will be identified then on the behalf appointed on the behalf of the accused petitioners humble submissions for discharge before our court. And this case is studied 14 hours today. Study from 8 hours, 8 a.m. and to 10 p.m. Actually, identify more important ingredients of this section. Number 1, date of occurrence, place of occurrence, never matching for the purpose of the case. Number 1, date of occurrence very important and place of occurrence very important. Prosecutions are plaintiff saying that in FIR or Azahar, because at the same we know that because we are lawyer, saying in FIR time 2 p.m. and place of occurrence, but charge sheet written in charge sheet time 3 p.m. 2 and 3 p.m. different 1 hours. And number 2, place another place, place show another place show and written in charge sheet. An investigation officer after investigation or complete the investigation and written or saying more important words in charge sheet and sent before our court, and it will be granted before our court because framing charge or not or discharge the accused petitioners who cannot be connected for the purpose of the crime or case, and prosecutions fail to identify or submit relevant documents who is the necessary for the purpose of the case. Because any case will be, any case, will be liable against the accused when the prosecution submit relevant documents. Number 1, doing act by accused petitioner present there at the place of the occurrence and identified or mentioning eyewitness, but main victim when they started the quarrel between prosecutions and plaintiff or prosecutions versus accused petitioners, main victim is absconding and there is no statement of main victim, and confusions and creations doubt for the purpose of the doubt, it will be going to on behalf of the accused petitioners because prosecutions fail. Number 2, creations doubt, date of occurrence in FIR versus date of occurrence in charge sheet are different, no match. Thank you very much watching and listening me, my dear viewers and my learned friends. Always support me, and I hope that doing better than each other and to better delivery for my viewers, and my lecture will be helpful who can practice in lower court or high court divisions. And every person or everybody, every viewers, always support me. Thank you very much. And this is very important for law students who are going to prepare bar council exam, pre exam or MCQ exam. And I hope that from experience it will be helpful and some questions from my lecture. And section 143, 506, 141, 142, 144, 145 and 147, 148, 146, right? Both are very important for upcoming exam, pre exam as a questions, and the students of for preparations bar council pre exams, and have to maintain daily routine and read those sections, and will be get the more opportunity as questions and from my lecture. Number 1, victim more person including in the case, and 2 victims submitted MC medical report before the court and written in MC. There is no sign of grievous hurt, but investigation officer written in charge sheet identified grievous hurt. Grievous, not grievous hurt, section 323. But a different confusions speech, it will be create doubt for the purpose of the case, because prosecutions bringing allegations, prosecutions has liability and burden of proof. Section 101 of Evidence Act 1872, and have to identify specific allegations. Prosecutions said in FIR, accused petitioners attacked me beside nearest house or place of another person who living nearest or relative, but same prosecutions submit speech in charge sheet. With weapon the accused petitioners attack me, but confusions and creations doubt and very sensitive and fantastic case measure to victim. Number one, plaintiff's father-in-law and plaintiff's nephew, and they are submitted to NC for the per person, but loss FIR before ago loss FIR against two victims, and from the long time two victims are absconding. Their name in case as a accused, but they are present for the case. It is very confusion. For the purpose of the confusion's benefit of doubt, creations doubt, it will be benefited for the purpose of the case on behalf of the accused petitioner. My dearest learned friends, Shafiq, learned friends, Parvez, thank you very much. Support me, and more friends or brothers or viewers support me, and always I am very glad and to support me and watching and listening my speech and my lecture. Because 14 hours I am studying today for the purpose of the case, and this case is the topic. It was topic for full days, and FIR and Ajahar more highlighting sentence of this case and more grounds to discharge the accused from the case. I hope that. And charge sheet, I have charge sheet highlighting more sentence, and these grounds are very important to discharge my client, and this case sent me and appointed me as a lawyer. Thank you very much, Advocate Parvez Bepari, and always Parvez support me and give me good opportunity become appointed as a lawyer in more cases. And from my career of legal when I started my career in Dhaka Judge Court. From beginning of my career, Parvez always support me. He was supporting me from my beginning career, and more other learned friends always support me till now. And my past journey, it was very hard, and every lawyer become as a advocate from the beginning career. This is the sensitive and very difficult situations, and it will be come by your hard working and some happiness, little of happiness knock me in my life for your support. And always I am brothers, I am friend of you and my every viewers, always members of my YouTube channel Saral Academy. Believe because participate your support and to continue your support me. This is the great opportunity in my life. And thank you very much, Parvez, advocate, Dhaka Judge Court, and good lawyer, and practicing in Dhaka Judge Court as a criminal lawyer. I hope that you will be good trial lawyer in your future life. And I always support you, Parvez, to continue your study and penal code, CRPC, evidence act. I always with you. And joint Sujoy Da, my dear brother and Dada, thank you very much. Always support me and appointed as a lawyer in more case. And believe me and trust me, this is the great opportunity from you. And I hope that you are all getting the better life and happiness with your family, living peaceful. And this day, the journey of this day, just spent for the case and starting 14 hours today for the case and find out more grounds to discharge my client. I hope that my client will be happy for the purpose of my work or delivery. And any client or learned friend give me a case. One case is the opportunity to turn for a career for par advocate. And I hope that always continue to respect my learned friends and my nearest brothers, viewers, and advocates who are appointing me their cases. And this is the big deal to turn over to establish me as a good lawyer in future life. I hope that from my experience and it will be continued, and I will try my best for any clients and any trustee learned friends. Actually, section 143 of the Penal Code. Please comments me my sound going to through by live clear or not. Please known me by your comments. I hope that this is my request to my viewers. I hope that my sound is clear, but send comments or doing comments, my sound is clear, I hope from you. Section 323, hard, and definition of hard, section 319 of Penal Code. And it will be hard or grievous hard identified section 320 of Penal Code. 8 ingredients of this section. And simple hard, section 319, and MC clear that MC provide that the doctors written in MC there is no sign of injury or injuries, and it will be clear that for hours there is no grievous hurt or there is no specific symbol of injury to the victim. But number one started the creations or clash of the case and base of main victim Rakhal Mofis. There is no Rakhal Mofis. There is no his statement and never connected in the case, and investigation officer said that not find out the main victim of the case Rakhal Mofis because the investigation officer hoped that he was flying or absconding, but date of occurrence and place of occurrence both are different and never match for the purpose of the case. Number one, FIR. Number two, charge sheet. This case will be continued. This case will be guilty of the accused. Never possible because there is no specific allegations and not submitted before the court. Relevant documents, prosecution failed because date of occurrence and place of occurrence are different. And 161, 5 or 4% given consent or statement under section 161 and they are match and not unique of both 161 statement and creations doubt and confusions, and these confusions will be continued and clear with specific evidence by the prosecutions. This is the prosecution's liability. But prosecutions have no speech, no sign of the legal statement, which is creations for the purpose of the crime. Crime is not easy matter. Creations, crime, and bringing allegation against the accused, it will be proved with evidence, because without proving or submitting relevant documents, being guilty of the accused petitioners, this is the injustice, because article 27, 28, 31, equality of every person, because we are citizen, my client is citizen, because we are Bangladeshi, and the guilty of the accused petitioner, the Honorable Court have to maintain the procedure, code of the criminal procedure, and with the relevant documents, but not submitted before Honorable Court relevant documents by the prosecutions. What is the cause of action of case, and how to clear or provide that this opportunity will be liable. There is no person, and which person will liable or not identified before Honorable Court, because durations, time management, and place of occurrence will be met or unique. Otherwise, this is not sign of unique allegations against the accused, because prosecutions cannot deny and produce relevant documents, and prosecutions fail or deny to submit the relevant documents. This is not cause of actions, this is not opportunity, because the Honorable Court have to maintain being guilty of the accused for the purpose of the allegations. Allegation will be specific to identified by the prosecutions and with evidence, but no evidence, because this case laws FIR only for harass the accused, and this is the counter case. Occurrence date 8 April 2025, but lodging FIR after delay 1 days. Laws FIR 9 April 2025, and 1 day delay or delay of 1 day, there is no specific worse. This is the prosecution's liability to identify specific words. Why do you lodge FIR after delaying 1 day? And two victims submit to MC. MC submitted, this is proof, the two victims are present there at the offense, at the place of offense, but two victims are accused before laws FIR against there. From them from there to victims are accused who are absconding from them long time. They are out of local area because police is searching to arrest the two victims, and two victims is the accused. Another case, absconding person never present at the offense of the case. This is the creations of doubt and confusion, where confusions, prosecutions, lodging affair, there is no grounds. How to not identify and started clash or offense when present the victim, main victim Rakhal Mujib, he was not given the consent, given the statement. An investigation officer said that main victim are not found because never statement of him. Police said that in charge sheet. This is the fact of the case, and he identified more grounds of the case have to spend 14 hours today, because this day একাদশী, এই একাদশী থাকার পরেও প্রায় 14 ঘন্টা সময় আমি আজকে এই মামলাটার জন্য দিয়েছি, সকাল 8টা থেকে প্রায় রাত 10টা পর্যন্ত চেষ্টা করেছি। আজকে যেটুকু সময় দিয়েছি, this is the great opportunity for me and being good lawyer in future, and everybody seeing dream, believe dream, belong good lawyers, and being good lawyer is not easy part of the human being, have to maintain discipline, and from my experience and everyday achievement, little of success, and will be assist your life to grow your career in legal field, because to establish in legal field is not easy, because percentage of advocate are more, and every years or after 2 years 1,000 lawyers act and practice in lower court and high court divisions. I appreciate the young lawyer who can done job as a lawyer, become advocate, but this is the challenge field in Dhaka Bar Association, in High Court divisions, and daily improvement in your life. Otherwise, never possible getting the success in your life. Because I can say to my friends, to my relatives, I practice in criminal side, civil side. This is not easy words. Practice in civil side, have to know all documents, CS, SA, RS, CT, BS, BDRs, and every Khotian Porcha, and buyer deed, sell deed, DCR, Dakila, very important part of the civil, becoming civil lawyer, and survey, measuring your land, dispute land, cause of actions arise, cause of actions for the purpose of the light. It will be identified and show the image to your client, and you are winner or given the remedy on behalf of your client, saying your words and have to say with confidence your client. This is not easy, but some person think that criminal practice is easy. It will be easy till bail, but after bail started trial. This is the challenging. Becoming criminal trial lawyer is not easy, because every year 100% lawyers and still dream as a criminal lawyer, but after 10 years or 20 years establish 5 or 7% being criminal trial lawyer. Criminal trial lawyer, measurement your relevant documents, maintain your date of occurrence, matching your date of occurrence, place of occurrence, and 161, 164 confession statement, eyewitness, and to show which documents before the court have to learn or study CRPC, Penal Code, Evidence Act, Special Act, নারী শিশু নির্যাতন দমন আইন, সাইবার ক্রাইম, মানি লন্ডারিং, more NI Act 420, 406, theft, dacoity, dacoity with murder, section 396, and section 302 murder or not amounting to murder, 304, definition of not amounting to murder, culpable homicide, 299 the Penal Code. This is not easy. From my experience, little experience, I hope that I think that I am criminal lawyer, criminal trial lawyer, but now I am practicing regular in high court divisions, and there is no enough time for me and switch my career in high court divisions from Dhaka Judge Court. But I feel very much as a trial lawyer, criminal trial lawyer in Dhaka Judge Court. I hope that, but we have sufficient time and you have to select one opportunity, one side, practicing in Dhaka Judge Court as a criminal trial lawyer, or otherwise practice in high court divisions as a criminal lawyer. And everybody, every viewers, support me and stay with me, listening my words and seeing me. This is the great opportunity for me, because every person is the superpower and every person is the great persons for you, for human being, and to your relatives, to your family, because every person is the great man and every person has more opportunity to do better than each other in your life. But spend the time with me for listening and watching me. This is the great opportunity. This is the great achievement for me. And your love, your honor, and send me and for me. Disturb free. 11:30, 35, 11 and 35. Wednesday at midnight. I hope that early started my life, but not possible for me, and I have more work and end or finish my work and to spend with my family. I'm so sorry, never started my life early. And this lecture will be helpful for my viewers and the person who can be practiced in lawyer court as a criminal lawyer or trial lawyer. This is the dream in your future. And practicing high court divisions and for police officer as investigation officer, starting investigation to maintain the procedure. Otherwise, the victim is sufferer for your negligence when you are started your investigations with negligence and complete your investigations. It will be noted in your diary because it will be very necessary important part when you started trial. The court called your diary because your diary is the most important evidence for the purpose of the case. You should submit or show your diary, and there is no chance neglect this duty. Thank you very much. And my learned friends with me or stay with me, thank you very much. And this topic is okay, and this topic end of the topic, and I hope that everybody will be helpful for my lecture. So thank you very much. Next time, next lecture with next new lecture will be present to you on live. And I am Saralkumarroy, Advocate Supreme Court of Bangladesh and founder and director Saral Academy. And the students who are serving or depressions for fail of your bar council, you can get registrations Saral Academy. I hope that first time you passed in bar council exam pre-written. Thank you very much. Good night and take care. Have a good night. Namaskar.